as the High Court did, in drawing from the sovereign authority it receives from the people, the High Court exercised bona fide authority. That is the authority granted to it under the Constitution. And therefore, it is demeaning, it is a tad arrogant to cast aspersion on judicial offices, to demean the image and integrity of courts for specifically doing what is decreed and declared in the Constitution. We submit a Kelsenian court, the High Court, enjoying the Kelsenian prominence loosely as it is in the Constitution, is a bona fide recipient of sovereign authority from the people of Kenya. Quickly, I move to public participation in the context of constituency and boundary delimitation. We have provided material in our bundle of authorities at page 428 to 429, and this is a scholarly article by Professor Tina Nabachi and Matt Liniger, Public Participation for the 21st Century. A lot has been said about public participation, but this was not said. Public participation enjoys its pride of place at Article 10. And Article 10 deals with principles and or values of the Constitution. Now, what is public participation? This is our submission, that public participation is a differentiated power track. What do I mean by a differentiated power track? It is authority belonging to the people, sui generis, and must be exercised in its quantitative and qualitative sense, and that is without apology. Public participation simply denotes that the people, in their sovereign superiority, must influence, must have input in important matters of their governance. Public participation in the context of constituency boundary delimitation ought to have led to the question with regards to Article 89(1). Do we keep the constituencies at 290 or do we reduce them? We are burdened by loans taken from all over. The burden is too much for us. Can we reduce the number of constituencies? That is a question that the people of Kenya should have borne, if the question was posed to them. The people of Kenya, in their madness or cleverness, could also have decided to increase the number to 400. That question was not posed to them. And we have submitted that public participation in the context of boundary review and delimitation did not happen. Telepathically, I can hear a question that he who proves, he who alleges must prove. My senior Elisha Ngoya addressed the commonsensical and the legal bits of it through the Election Act. I want to answer it in the political sense and drawing from authority from this court. In the political sense, being that we are citizens and not subjects. The citizens of Kenya, Nafula from Trans Nzoia, Mwikali from Machakos, Auma from Uyomararieda, Wajiko from Nyeri, ought to have been asked about whether they want to increase or decrease the constituencies under Article 89(1). So we allege that did not happen. Now, to those who will tell us that since we are alleging we have to prove that public participation did not happen, allow me to refer you to an authority of this court, Civil Appeal number 6 of 2018, the case of Kesi Jindwa Karuku versus Steelmakers. This court said that a negative inference such as we are making cannot be on us to prove. It is for those we are citing that negative inference to certify this court that indeed public participation did happen. It did not. As I wind up, and in conclusion, one Kenyan who unfortunately demised, and Kenyans quite clearly remember him, the late senator for Homa Bay, one Gerald Otieno Kajwang, contributing to the Bomas Devolution Committee, said this: "We are the people. We must disperse power. We must share resources. We have to spread power horizontally and vertically." Quite animated as he was, that is the message of this constitution. Power has to be deconcentrated from the center. The people have to have their share of power as they envisaged under the constitution. Public participation being one track of authority as we declared and decreed unto ourselves. Another Gabriel, and this is Gabriel de Riquetti Comte de Mirabeau. This is a French legislator in the context of the ousting of King Louis XVI, a despot par excellence during the French Revolution. Told this to the military guards who were sent to come and disrupt the Constituent Assembly. I will say it in French and I will translate it in English. Allez dire au roi que nous sommes ici par la volonté du peuple et que nous n'en sortirons que la force du baïonnette. For those who don't understand French, basically, what Gabriel de Riquetti, Comte de Mirabeau, said is this: that go tell your master, your king, that we are here by the will of the people and we will only be forced out by the force of the bayonet. That's an exhortation for this honorable court. Mudomi Thiankolu, addressing you yesterday, told you not to drop the sword. When that sword was dropped, we had the radical surgery, where judicial officers were treated inhumanely and demeaned for extraneous reasons. The tenure of the judges was removed for extraneous reasons. The constitution was reduced to blanket piece of papers. Gazeti tu ya kusoma. That is what we hear them say. This constitution represents the solemn will of the people of Kenya. This constitution was inked in blood. This is a product of a constitutional moment. 2007, when people died, killed, mercilessly butchered. That led to this constitution being and coming into life. It cannot be, as has been suggested from other quarters, that this is an elite pact. Hell no. This is a product of blood and sweat of ordinary Kenyans. I end by saying this to the Honorable Court, and in echoing the words of a very noble son of Africa, Deputy Chief Justice Emeritus of South Africa, an admirable man, Digang Moseneke, the courage of principle. You have to have courage. The principle is in this constitution. Take fortitude in what it says. Courage, principle, adherence to our constitutional pre-commitments. Those are the only saving lines for us not to drop the sword. The insults will come, the calumny will come, the indignity will come. But to you and for the people of Kenya, it behoves you to do one and one only thing: pre-commitment to the Constitution, And that alone will suffice. I submit. Thank you.
Thank you, Council. Who's next?
May it please the court. My name is Kevin Doho Masharia. I appear with Edgar Busiega for the...
Is it Kevin Macharia?
Yes, Kevin Doho Masharia. I appear with Edgar Busiega for the Kenya National Union of Nurses. Our petition in the lower court was petition number 397.
Sorry, you say you appear together with Mr. Busiega?
Yes, Edgar Busiega.
And remember we had given 15 minutes.
Yes,
Thank you. Thank you.
Yes, I'll try.
Thank you.
Because of the little time, the 15 minutes, I'll just highlight the documents,
Yes.
and Mr. Busiega will highlight the cross-appeal and the issues arising out of the betrayal of the legitimate expectation of healthcare workers. We filed a notice of address and a notice of cross-appeal.
Council, can you try and raise your voice, please?
Yes. We filed a notice of address and a notice of cross-appeal dated 8th June 2021. We then filed submissions dated 9th June 2021, a list and digest of authorities dated 27th June 2021, plus additions in volumes A, B, and C. Then we relied on the petition and submissions from the lower court found on the BBI record from pages 1257 to 1353, and our issues in the lower court judgment were addressed from paragraphs 620 to paragraphs 632. We had annexures which are found on volume 3, paragraphs, page 1313 of the BBI record of appeal, and the gazette notices at volume 4 of the BBI record of appeal at between pages 1574 and 1576. The position of our client is we oppose the BBI bill only as far as it excluded the Independent Health Commission as found to be found as a constitutional amendment. I'll give a few comments before I sit down. On the basic structure, we submit that the Constitution does not contemplate eternity clauses. We rely on an authority called Dead Hand Constitutionalism, Honduras, and the danger...
Counsel,
yes.
Let me understand you. You are, other than for the part where
Yes.
the learned judges did not agree that you ought to have been included in the amendments.
Yes.
In actual fact, you are actually opposed. No, you are supporting the appeals.
Yes, somehow.
What do you mean somehow?
Because when we want that health commission,
Just a
the
moment.
Constitution must be amended to include the interests of
I'm
the
looking at
healthcare
your
workers.
prayers.
Yes.
Your prayers are at page 2 of your notice of cross appeal, and you're saying that you want the judgment delivered on 13th to be set aside. The entire judgment be set aside, and
The petition to be allowed.
your petition be allowed.
Yes. That's as far as we go.
So you
That's
want
as
it-
far as our submissions go.
So you are supporting the appeals.
We are sui generis litigants. We only have one issue to prosecute and find a way to find the interests of our clients provided for.
So perhaps don't go into the basic structure and such other things. Just go straight to your
yeah.
issue of that you should have been included.
We have to, because if basic structure applies, our client will not have a way to get what they want.
Oh, okay.
Yes.
Sorry, how does then basic structure have to do with what Kenya National Union of Nurses want?
What we say-
you have one singular issue.
Yeah. What we say is this: the Constitution is amendable, and it can take into account the healthcare issues, especially the interests of our client. Because of the shortness of time, my colleague will deal with those issues. Yes, Mr. Busiaga.
And that's why, of Of course, it's too late now. Ideally, you should have come earlier to support this whole business of the appeal.
He'll deal with those issues, especially
just
on that issue.
Just a moment, Council.
Yes.
That you should have come earlier. It's more sense for us, in terms of where our head is, what we are focusing on now. But
yes.
I guess it's your time.
Okay. From that aspect of what you're asking, we adopt our submissions and we ask that you give them credence to our prayers. And because of time, I just promised my colleague that I'll take 3 minutes. My 3 minutes are up. I rest.
Thank you, Your Lordships. My name is Edgar Busiega, for the record. In the interest of time, I'll submit without necessarily referring to documents. Perhaps for the bench to understand the issue at hand and the position of the Kenya National Union of Nurses is that the Constitution Amendment Bill of 2020 is opposed. Your Lordships, it is opposed to the extent that the nurses were not made part of the process. And what was choreographed as a public exercise in terms of seeking public views, in which the nurses presented their proposal, that proposal was ignored. Your Lordship, it was admitted in the first report, which is popularly known as the BBI Report 2019. But subsequently, when the amendment bill came through, it was not part of it. To that extent, therefore, we oppose the Constitutional Amendment Bill and state that it is actually a legal fraud. A legal fraud in the sense that it does not represent the wishes of the people. My lords, the nurses were made to believe that this was a process towards uniting the whole country. And they went ahead and told people, bring your views. Now, we are being told, and that submission was made by Senior Counsel Otienda Molo, that the promoters of the bill are one Dennis Waweru and Junet Mohammed. The nurses feel cheated to the extent that the promoters of the bill, to the best of their knowledge, was the President of the Republic of Kenya. And since the nurses were willing to be part of building a country, they subjected themselves to this process. Along the way, it turned out to be a farce, not intended to achieve the will and wishes of the people, but as a vehicle to serve their own private interests. In this case, the interests of the President of the Republic of Kenya and his erstwhile foe and now friend and brother, Honorable Raila Amolo Odinga. To that extent, we oppose the Constitutional Amendment Bill. If the process had been initiated with the inclusion of the Health Service Commission, an independent health service commission, with the same status, such as the Judicial Service Commission, the Teacher Service Commission, the nurses would have thought about it. The eminent submissions I've had is that the appellants want the reggae to stop from where it was paused by the High Court. We cannot allow that. We cannot be taken for a ride. the Constitution Amendment Bill does not represent the wishes of the people. Now, I'll address the element of legitimate expectation as argued in our documents. Your Lordships, the cornerstone of legitimate expectation arises from a considered assurance. In this manner, nurses, bring your views, we look at them. We presented a memorandum for an Independent Health Service Commission. In essence, it was to cater for the human resource element and to liberate the healthcare workers from the arms of the governors, the county government. We have seen the turmoil in the health sector in this country. So we had subjected ourselves to this process to the extent that let's build this country together by reducing the numerous strikes. Let the nurses, let the healthcare workers manage themselves in terms of the human resource element. Let them take charge of their recruitment, disciplinary issues, and etc. Now, this proposal was considered and indeed brought out in the first BBI report. To that extent, it is our submission that constituted a promise. A promise upon which the nurses had a belief that there will be an Independent Health Service Commission. That promise could only be taken away through a procedural process. And the procedural process here is captured under Article 47 of the Constitution of Kenya. The nurses were entitled to be heard, to be subjected to a process of being heard and being given reasons why their document, their proposal had been omitted. The reasons given were that there were opposing views. Where these opposing views, they were never attached. Section 112 of the Evidence Act captures this position. They had the responsibility to bring this evidence. There are no opposing views, and therefore, this whole process was all meant to mislead the healthcare workers. To that end, I seek your findings that the Constitution Amendment Bill 2020, as approved, passed through the assemblies and the two houses, is unconstitutional. And if this court will be minded at the end of it all, and that we leave it to your discretion, to find that the process is legal, then the healthcare workers must be included as part of it. That is our submission, unless there's any question from the bench.
I don't think there is. Thank you very much.
Thank you.
Can we move to no, yeah. I think he has already said I would have done this. Thank you. Thank you, Mr. Busiega, for using your time well. Mr. Chair Dudley, you have 30 minutes.
Thank you, my Lord. My Lord, I draw your attention to our grounds of affirmation of 9th of June, our submissions of 23rd of June, our submissions replying to the county assemblies on the question of popular initiative of 26th of June, and to volume 1 and 2 of our case digest of the 28th of June. We filed also one supplementary case list
on the 29th of June, and one bundle of undated authority replying to the views of amicus on the 30th of June. My Lord, for the appellants to win, the court must do 4 things. 1, adopt textualism as a method of interpreting the Constitution and answering the issues in this appeal. Basically, the appellants are telling the court that as long as you follow Article 255 to 257, you can invade, deconstitute, replace, and alter any part of the Constitution without reference to the primary constituent power. Secondly, the court must elevate political elites above the people, which people hold the constituent power, and only they can make or unmake the Constitution. I say that because, my Lord, the Attorney General and BBI tell you that the Constitution was made by political elites, and they do that relying on the 2008 Act. That Act, from its long object, was to complete the process of making of the Constitution. It didn't start there. It started with the 1997 Act, the Constitution of Kenya Review Act of 1997, which we've supplied, my Lord, in our supplementary case list. I request the court to turn to that act and to look at its long title, my Lord, which was an act of parliament to facilitate the comprehensive review of the Constitution by the people of Kenya and its eventual alteration by parliament. My Lord, that act, far back in 1997, recognized the constituent power. How then can we unknow what we knew in 1997? That only the people can make fundamental changes to the Constitution. My Lord, you are told that no constituent assembly was formed. But if you look at Section 2B of that Act, you find the constituent assemblies. 2002, they were formed at the district level, and there was the Bomas conference which happened. And so, my Lord, for the appellants to win, you must ignore that history, that the people were at the center of the process of making the Constitution and exercising their constituent power. And if you look at the guiding principles in that act, my Lord, they were again consistent with the people's constituent power, saying that it was meant to provide the people of Kenya with an opportunity to actively, freely, and meaningfully participate in generating and debating proposals. This is important to alter the Constitution. Constituent power, Constitution-making power, the original power, not the derivative power, which reposes in 255 and 257. My Lord, the third thing you must do, and this is the last, is to upset a settled theory in comparative constitutional law, the theory of constitutional change. That theory, my Lord, in a word, is to the extent that the power to amend the Constitution is not the power to annihilate it. And my Lord, before I come to the bulk of that, the Attorney General accepts Yaniv to be an authority. Senior Counsel George Oraro told you so. Then when the court asked senior counsel about the familiarity between India and Kenya, that was Justice Musinga, if I remember, senior counsel's response was, there's no similarity. Yaniv, at page 42, records the answer to be as follows: that India was faced with far-reaching attempts by Prime Minister Indira Gandhi to amend its constitution. We have before you 78 missiles directed at the heart of our constitution. Yaniv, page 42. That is the context in which the Indian courts applied the basic structure doctrine. My Lord, the Indian court was not even the founder of that doctrine. They applied what Carl Schmitt had long spoken about. My Lord, in his book on the theory of the Constitution, which we've supplied to the court, you'll find Schmitt saying that the Constitution does not make itself. It is made by a higher power. That is the constituent power. And that is at page 559 of volume 2 of our record of appeal. Then he also says, my Lord, that changing the Constitution is not a normal state function, like establishing statutes, conducting trials, or undertaking administrative tasks. It is an extraordinary authority. It is an authority that belongs to the people. Senior Counsel James Orengo, who inspired many of us, including myself, to the law, left me confused. He posed the question, can the people exist outside the Constitution? The answer is yes. The people make the Constitution. Exercising their sovereign power and sitting as a constituent assembly, yes, they can alter the Constitution. They can change this country into a monarchy. And they can reorganize our modes of government. My Lord, Schmitt tells us on page 559, the last paragraph, that the authority to make amendments, I quote, contains only the authority to undertake changes, additions, extensions, deletions, etc., and that it is not the authority to annihilate the Constitution. In other words, you cannot use that power to make a new Constitution. And so that I move from Schmitt to someone else, my Lord, if you look at page 545 of volume 2 of our case digest, you will find Schmitt telling us that a constitutional law is the enabling legislation of the constitution-making will, and that it contains in it all that you need, so that if additional individual norms are written into the Constitution, that only has a technical, juristic meaning. The constituent power does not have to be written into the text of the Constitution. And that disabuses the views of Fombard, who tells you that because Article 255 and 257 do not contain the words Constituent Assembly or Basic Structure Doctrine, they cannot be invoked by the court. My Lord, did Kenyans intend that this constitution, like the current one, could be replaced, abrogated, altered gradually by amendment. I urge you, my Lord, to look at your screens for a moment and let us see also why the High Court's finding that the inquiry is factual makes sense. Kindly show us amendment number 7. My Lord, this is from page 1150 of the Attorney General's Record of Appeal, Volume 3.
Sorry, we may not be able to read it from here, but
Sorry,
are you able to just
That's okay.
refer to where it is
Very
from,
well.
so that we can follow?
That's okay, my Lord.
Which volume?
Volume 3
Volume 3
of the Attorney General's
of
Record of Appeal,
AG's Record of Appeal.
page 1150. If it could be turned over to the court, I would be grateful. My Lord,
Can you have the volume? Yes, continue as they get it.
thank you, my Lord. My Lord, amendment number 7, for example, of Kenya's constitution gave the president the power to order detention without trial, to prohibit any meeting, procession, or society, to impose censorship, to impose curfews, and to draft anyone into the disciplined forces, including the NYS. That amendment touched the basic structure of the Constitution. It did. The second amendment, which turned Kenya from having a prime minister to a president, also went to the basic structure of the Constitution. And the one which deleted the counties, then we call them regions, also touched the basic structure of the
you're
Constitution.
talking of number 7.
Amendment number 7, my Lord.
Then
Then-
just refer to the numbers in the interest of time.
Thank you, my Lord. My Lord, there's also amendment number 14, which made Kiswahili the only language in the National Assembly. That's an amendment because it is consistent with the body of the Constitution. It does not make fundamental changes. And moving forward, if you move to the further pages, my Lord, you'll find some of the attempts to amend the current Constitution. And you find proposals, for example, to deny the High Court jurisdiction over questions pending in Parliament. An amendment touching on the High Court's jurisdiction is an amendment touching on the basic structure. And so, my Lord, this inquiry must be factual. You must wait for the amendment to come before you, look at it, look at the body of the Constitution, its language, and decide if or not that amendment affects the body, affects the basic structure. There is an argument that the counsel who preceded me has made about the dead hand claim, that by imposing strict rules on constitutional amendment, we'll be tying the hands of future generation. That is not a new argument. It's an argument that Fombard also makes, my Lord. The answer to that argument is found at page 4 to 5 of Yaniv Rosnai. In justifying the amendment rules, he looks at both sides. Yes, the Constitution must be flexible, but it is not amended the same way as a statute, a fact that Parliament knows. And that is why the Interpretation and General Provisions Act does not apply to the Constitution. The Act recognizes its own insufficiency. It tells you, don't look at us when it comes to constitutional interpretation questions, including amendment. And my Lord, the Constitution cannot provide for its own repeal. No Constitution provides for its own death. And so special rules apply. Hans Kelsen, which you will find quoted at page 39 to 40 of Richard Albert's book, which is the supplementary authority we supplied to you in response to the amici, tells us that because the Constitution is the grand norm, it's at the base of the national legal order, it is desirable to give it a more stable character. And so, my Lord, special rules apply to the amendment of the Constitution. These rules can be written, like in Article 255 to 257. They can also be implicit, discoverable by reading the Constitution holistically. My Lord, if it were not so, can we say that if you get the numbers and follow the procedure in 255 to 257, you can come one day and delete the judiciary or deny it its independence? It has happened before. I do not speak in the abstract. Can we say that as long as you get the numbers, 1 million signatures, get people who are sufficiently angry with the counties, you can come and delete the chapter on devolution? It has happened before. Can we say that as long as you follow 255 to 257, you can come and kill the Senate? It has happened before. All the amendments, each one of them, that killed Kenya's constitution followed the procedure. Each one of them. In fact, at times, the threshold was lowered to make it easy for amendments to pass. Some passed in a single afternoon. My Lord, imagine being detained without trial because the Constitution has ordered it. Where does one turn to? And so the Constitution must have a higher place than ordinary legislation. The mistake that my my friend Mr. Paul Mwangi makes is focusing on India as the origin of this doctrine. My Lord, while they see, I quote, a doctrine of a highly doubtful origin, rejected, again I quote, by a vast majority of scholars, a vast majority of courts, and which is repudiated by an overwhelming number of scholars, Yaniv Rosnai sees a growing trend towards adopting this doctrine. That is Yaniv at page 70. And Richard Albert, another authority in this area, whose work you will find in our authority replying to Amici submissions, also sees the same trend. Richard Albert, you'll find it in volume 1. You'll find that in Richard Albert's book, where this has gone to Belize and the Czech Republic, Latin America, my Lord, Asia, Africa. It's no longer an Indian doctrine. It never was to begin with. Carl Schmitt was not even Indian anyway. And Paul Mwangi cited to you Professor Upendra Baxi as dissuading you against applying this doctrine. I wish he cited to you what Upendra has recently said about this judgment, David Lee, in his article, Hooks, Pillars and Foundations. He finds that it's a legitimate doctrine and the Kenyan High Court placed the people at the center of the Constitution, unlike Senior Counsel James Orengo. My Lord, that doctrine is so theoretically sound that the the Kenyan judiciary has already held that the basic structure doctrine binds it in interpreting the Constitution. You find that at the CCK case, para 362, where the Supreme Court says, and I quote, the Kenyan Constitution sets to the judiciary, my lords, its barricade against destruction of its values and weakening of its institutions by forces external to itself. Also look at the Martha Kerubo case, which supplies the various names to these doctrines. My Lord, even if the appellants block you from applying what they're calling the basic structure doctrine, what about the Colombian constitutional replacement doctrine, which applies to the same theory, the theory of constitutional change? The power to amend is not the power to repeal or to destroy. My Lord, at page 215 of Yaniv, you'll find Yaniv saying that the Constitution's language is not just the explicit language, it's also contextual, because the Constitution has a history. And that's something the Supreme Court explains in Speaker of the Senate. It says that the Constitution is a document of compromise, Speaker of the Senate, para 156, and so that compromise facilitates ambiguities, vagueness, and gaps in phraseology. But constitution making does not end at promulgation. It continues with interpretation. And so you have the chance before you to make or unmake the Constitution. My Lord, to allow the appellants to win, you'd also have to disregard all modern constitutional law comparativists. Paul Genyap, we've supplied you with her work. Hannah Lena, David Landau, Rosalind Dixon, Mark Tashnet, all modern comparativists, because their work support the High Court judgment. I move briefly, my Lord, to the question of presidential immunity. And my Lord, the President does not enjoy absolute immunity. If he did, for example, under Article 143.3, the President can be sued after he leaves office. It freezes time from running, 143.3. What sense would it make to sue the President after he leaves office for official acts? Why would we bother a retiree after he leaves office? And so in short, Article 143.3 must be interpreted holistically, that's one, as the High Court has done recently in Katiba Institute, a case I was privileged to argue against Senior Counsel Waweru Gatonye. The President, on being sued for failing to appoint the 41 judges, raised a preliminary objection urging his absolute immunity from all processes. The High Court overshot that. We ask you also to do the same. Number two, there's no single president that from any country in the world that gives the president absolute immunity. President's Counsel could only rely on Nixon versus Fitzgerald, but Nixon versus Fitzgerald had different facts. It was a claim for damages for unfair termination. It was not a public law claim like the one before you. So it does not support, it helps us. And if you look at it, my Lord, you'll find phrases like private lawsuits, damages, liability for damages. It prevents private lawsuits. And the reason in Kenya is because of 165. Anything done or said to be done under the Constitution falls within the jurisdiction of the High Court. My Lord, lastly, as I yield the floor to my learned friend, Mr. Ian Madenge, is that presidents have routinely been sued around the world for public wrongs. President Trump 2 years ago, President Jacob Zuma, recently sentenced to contempt. And my Lord, if anything, and I say this with a lot of respect, the current president has shown us why a president must not have absolute immunity from all proceedings, especially those ones touching on the Constitution. My Lord, I rest my submissions and request you to call my colleague, Mr. Ian Madenge, to the podium. Thank you, my Lord.
Thank you, Mr. Chair. 10 minutes, Mr. Madenge.
Good afternoon, my lords.
Good afternoon, Mr. Madenge.
Let me start from where my colleague has left by assisting the court on two issues. The first issue, my lord, is whether the text of the Constitution supports basic structure. And I will be making two arguments, my lord. The first argument is that the text of the Constitution indeed supports the basic structure. And to illustrate this, that the Constitution has a core content. There's no Constitution without a core content. Number two, my Lord, is that the Constitution has foundational and prior principles. And I will demonstrate it to you, my Lord, and my lady.
Foundational
and prior principles.
Okay.
What we call immutable principles in constitutional law.
Yes.
To demonstrate that, my Lord, is Article 4.1 of the Constitution. 4.1 indicates that Kenya is a sovereign republic. It just declares the state of Kenya. It does not in any way grant Kenya sovereignty. That can be contrasted, my Lord, with Article 156.1, which establishes the Attorney General. Number two, my Lord, even more important and revealing is Article 4.2. It provides that Kenya is a multi-party republic founded on national value. So the foundation of Kenya and the Constitution is indicated in Article 4.2. That is what we call the value system of the country. You find it there. If you change that, you are replacing the Constitution. That is the value system expressly provided. And one claim, my Lord, that I think will not be controverted is inherent nature of human rights. You find it in Article 19.1 and 19.3. Inherent nature. It indicates that that is prior. It is immutable. The Constitution does not grant it. It cannot change that. I will not go on, my Lord, to discuss what was discussed on the issue of Kasevananda, but there is a misrepresentation. The High Court did not follow Kasevananda, line, hook, and sinker. It adopted it to our situation. Kasevananda said you cannot amend. The High Court says you can amend using the 4 steps which call in the constituent power. I left that point there and move to the second point, which is even more important, my Lord. The second point, my Lord, you are told that the president is the one who promoted the popular initiative. I will not delve into that. The question that I'll seek to answer, can the president promote? And to answer that question, my Lord, I'll refer you to authority number 78. Authority number 78, that is volume 2, page 677 and 673. It defines what is popular initiative. We provide an authoritative definition of popular initiative in 673 to mean the rights of the people, and the key word in both is the people, my Lord.
You say page 677.
677 and 673. 677 is paragraph 4. My Lord, then that takes me to my 3 arguments why the president cannot initiate popular initiative. The first one, my Lord, and I hope I'm not too fast, it's only the time that is harassing me.
Yes, proceed.
Number 1, my Lord, is that the president has no power in the Constitution to initiate popular initiative. I have looked at the entire chapter 9, my Lord, of the Constitution, and in particular Articles 131, 132, and 133, which provides for the powers of the president in extensive manner, and expressly so. None involves amendment of the Constitution. I contrasted it with the previous Constitution, my Lord, that was repealed, and in particular section 423 and chapter 2, the president's power were very narrow. This time we provided them extensively, and none involves amendment of the Constitution. So the framers of the Constitution did not want the president to amend the Constitution. Even more important, my lord, is that Kenya, the argument number 2, Kenya adopted popular initiative as opposed to government initiative. Globally, my lord, there has emerged 2 types of initiative: government initiative and popular initiative. And we have done a comparative study of the practices. And I want to refer, my lord, you to our Band of Authorities, Volume 2, Authority number 79. This is key, my lord, to the determination of this case. Authority number 79, page 736. That is Volume 2, Authority number 79, page 736.
What is the authority? Please mention it.
It is Andre Amani, Referenda and the Citizen Initiatives. Andy Amani, Referenda and the Citizen Initiatives. And that authority, my lord, contrasts 2 types of initiatives that countries can adopt. The first one is government initiative, and it identifies 2 characteristics. And that is what you'll find also in Turkey, to give an example. Number 1, it can only be initiated by the government, either legislative or executive, my lord and my ladies. That is the first characteristic. The second characteristic, my lord, is that the government decides whether to call the referendum or not. So like Turkey, it's only the president who decides whether to call referendum or not. That can be contrasted with what we call popular initiative as described in that authority. And popular initiative has the following characteristic. Number 1, it is a people's pushed process. Number 2, it has signatures, threshold of signatures. That is page 737, authority number 79. Page 737, authority number 79. That answers that question decisively, my lord and my ladies. And lastly, it has verification of the signatures. That is a key element. I don't need to say any more on that, my lord, but let me give you even the third justification, my last argument. My lord, the president being involved changes the character of democracy at play. The third argument, altering the character of democracy at play in popular initiative. Changing the character of democracy at play in popular initiative. And to understand the character of democracy at play is our authority number 78, page 677 and 676. It says that it is direct democracy which is at play. Direct democracy has a number of characteristics. Number 1, it is pure form of democracy. It is an act of self-rule. It is a bottom-up democracy. Bottom-up democracy by the people. Number 3, it recognizes the ultimate sovereignty of the people in Article 1. So that democracy is subverted. That is my argument, my lord. Is subverted if a representative or the executive is involved in popular initiative. It is subverted. It ceases from being direct democracy to what we call representative or indirect democracy.
Last submission.
The last submissions, my lord, is that the Constitution, and this has been said, is that the Constitution distinguishes between the people and the representative. That is Article 1, 2, the people may exercise directly or through their representative. 1, 2, my lords. And number 2, Article 255 3b. Article 255 3b says that the amendment be brought by the people and the representative, or the representative. So the representatives are not the people as per the Constitution. That is the conclusion, my Lord, that the representatives are not the people. And for that reason, my Lord, I was supposed to address another issue, but I think...
No, that's a good place to stop.
Yes.
That is the representatives are not the people. Thank you very much.
Thank you, my Lord, and thank you also for your kindness and giving me this time.
Thank you. Now, we are progressing fairly well. We will take a lunch break, and when we come back, we have Mr. Oluchir and Dr. Eboso. Yes, so we resume at 2:30.
This conference is no longer being recorded.
And they say, as an example, 255(1)(g provides for amendments relates to the independence of the judiciary, which should be approved by a referendum. So, Your Lordship, is it possible that what is being told to this court as a basic structure is not an amorphous organism put above the Constitution, that again, as we say, as statutes, we look up to the Constitution? Does the Constitution look up to another document that is amorphous, known as the basic structures? In fact, the judges in this court seem to suggest that what they would consider to be the basic structure of a constitution is actually the A to J in 255(1). And they say they can be amended as long as there is a referendum. That's what they say. And they say that specifically and expressly in the places that I've said. Your Lordship, when you retire, look at Kivuit well. Finally, when you're talking of the rules of if you want to amend, because the court made a finding that if you want to amend through a referendum, it is unconstitutional because their laws for referendum are not enacted. You also see chapter 16 of the Constitution, which talks about amendment, is one of the unique chapters that are not covered in Schedule 5 to be having what I would call constitutional dictates on legislative framework. The 5th schedule has listed very specifically the articles that must be enacted by the dictates of the Constitution: Environment and Land Act, Employment Labor Relations Court, National Land Commission. The one for legislation for the framework for referendum is not one of them, as IBC submitted. However, it is provided for in Section 49 of the Election Act. Your Lordships, 4 seconds back to you. Thank you for your time.
Thank you, Mr. Gilbert. First to fifth respondents, are you ready? Yes.
Now, good morning, my lord. My name is Mubomi Kolu.
Good morning.
For the 76th respondent, there is a small housekeeping matter.
Sorry, Mr. Tiankolu, you are for?
The 76th respondent.
You are the one who is beginning the...
No, my lord, but I have the permission of the president of the Law Society to raise a small issue that is of concern for all the respondents.
Yes.
My lord, when we came